SJC-11094, Commonwealth versus Scott.
Excuse me. Good morning, Your Honors.
Good morning, Mr. Fellows.
Michael Fellows for Lanny, Steed, Scott. The court has granted further appellate review on one very narrow issue, and that is whether the presentation of evidence that the victim in this case suffered a grade 2 liver laceration by itself was enough to establish a serious bodily injury under 265 Section 13A. The defendant's contention is that in order to establish serious bodily injury, the Commonwealth needed to prove that the liver was actually impaired, and that impairment and injury are not quite the same thing. Our position is that this is something that required an expert to testify to. The classic case is Commonwealth v. Jean-Pierre, not classic case, but recent case, where the defendant or the victim suffered a broken jaw. Now, this is clearly an impairment to a bodily function that would fall under the statute, and it's something that the average juror would understand. I see a broken jaw. I know that this person is not going to be able to eat. That is an impairment.
Because it affects functionality?
Precisely, Your Honor. Yes. If you could imagine somebody being hit very hard in the jaw and it being a painful injury, but it not actually affecting the functionality of the jaw, it's not a serious bodily injury.
But in your reply brief, you quoted dictionary definition of impaired as diminished, as in strength, value, or quality. And I wonder whether the evidence here wasn't sufficient to find that the victim's liver was diminished in value or quality. I mean, can you really consider a lacerated liver and an unlacerated liver to be of equal value?
Well, I think the term value in that case isn't really in this case it would have to refer to strength, which I would interpret as ability, which is the liver doing its job? There's a case cited in my brief for a slightly different proposition, but as I was reading it last night, I realized it illustrates this point for me very well. It's Commonwealth v. Copeland. And in that case, the defendant wanted to present medical records showing his arm had been injured seriously. And he wanted to use that evidence to show the jury that he was incapable of carrying a shotgun during a robbery that he was charged with. And the appeals court said that while the evidence showed that his arm was injured, it wasn't relevant because without an expert, he couldn't demonstrate to the jury that it was impaired. He couldn't show them that it wasn't functioning correctly. And I think all of the cases that I've seen, this is the key, the crux, and it's what differentiates a simple injury from a serious bodily injury.
Now, what is impairment of a bodily function as distinct from impairment of an organ under your interpretation?
Well, in my view, that is both explanatory and also captures things like the jaw. Again, it's not a limb, it's not an organ. What is it?
Okay, but under your interpretation, could you have impairment of an organ without there being impairment of a bodily function?
I would think that the two are essentially the same, that the organ has a function, whatever that function is for that particular organ.
Okay, now, the problem is that the legislature chose to say impairment of a bodily function, limb, or organ. So, and usually we don't view words to be duplicative or meaningless. What meaning then should we give to the legislature's choice to not merely say loss or impairment of a bodily function, but loss or impairment of a bodily function, limb, or organ?
Well, again, I believe that the legislature is saying that the Commonwealth has to prove that the organ is impaired. They can also prove that a bodily function is impaired. It's giving them more leeway in trying to establish a serious bodily injury for something that isn't a limb or isn't an organ. In this case, we have an organ, and it's not enough to show that it was injured.
But doesn't No, it doesn't. What supports the bodily function if not organs?
Well,
I mean,
all
there's
different
a-
parts of the body have functions. Each organ itself has a function. The liver's function is incredibly complex, and
But when you diminish the functioning of an organ, don't you also diminish the function of a bodily function? I mean, the whole idea of it is sort of a redundancy if we have to read in impairment to mean loss of functionality.
I think Section 265.13K illustrates the difference between impairment specific to the organ and impairment generally to the body. 13K defines serious bodily injury similarly to 13A, but 13K also defines bodily injury, not serious bodily injury, just bodily injury, as impairment to the physical condition of the person as through a certain number of injuries, one of which is injury to an organ. Now, if injury to an organ can be just a bodily injury under 13K, then clearly there must be something further to establish a serious bodily injury, and that is, as described in serious bodily injury definition in 13K and in 13AC, an impairment. It's specifically directed towards the term organ. And my position is simply that that means that the Commonwealth needs to demonstrate somehow that the liver was not functioning as it ought to have been.
Well, was there any evidence at trial from the victim to the effect that his doctor restricted certain activities or restricted the consumption of certain food or told him he couldn't drink or something like that?
Nothing like that that I can recall from the
Didn't I
record.
read somewhere that she
test-
started to say something and there was an objection which was sustained because she isn't a medical expert?
She
or still?
testified that she had, or she started to testify that she had a liver laceration, but that was objected to. As far as I can recall, there was no testimony about any restrictions in physical activities, and the medical records themselves demonstrate there were no tests done of her liver function. There was, she had pain, and obviously any injury of this kind is going to cause pain.
Did the medical records indicate, in the discharge notes that she wasn't supposed to drink for 2 weeks or something like that?
Nothing like that,
Taking
Your Honor.
Percocet or something. She was taking something.
Other than pain medications, that was
They derivatively say you're not supposed to drink, but there was nothing specific about
nothing.
that.
No.
What was
simply
the reference to free fluids? What,
Well, this is part of the problem, Your Honor, is I don't really know what that means. The records say there was free fluid in the gallbladder fossa. I don't know what that means, and I'm pretty sure the jury doesn't know what that means. It said it may have been blood.
well, let me put it a different way. I take it from the medical records that the normal situation is one does not have free fluids.
Well,
And so the presence of the free fluids suggests something unusual, abnormal, different?
True, Your Honor, and it could be caused by the liver laceration. It could be similar to a bruise on the arm. But again, do we charge someone with a serious bodily injury when they injure somebody's limb, but that person's limb is still usable, or is it when it's a more serious injury where the limb is broken? It's my position that serious bodily injury, the reason we have these enhancements is because the injury is more serious. Secondly,
Is there
without
anything
an
we can
expert, I
derive
don't think you can establish that free fluid is linked to the liver laceration. How was a jury supposed to know? I believe a jury would have to speculate.
So there was no evidence or anything evident from the records that there was any treatment
Other than
or
pain?
testing of the liver, anything related to that?
There's no evidence in the records that anything like that was done. But again, a jury wouldn't even know by reading these records. There were blood tests taken. A jury would have no idea what any of this meant. There was free fluid in the pelvis region. What does that mean? Is it connected to the liver? I don't know, and I don't think an average juror would either, which is why I believe an expert was required in this case.
You may have addressed this, and I apologize if you did, but when the appeals court uses the definition, I mean, Jean-Pierre is really about permanency and not
Yes,
being.
Your Honor.
And when it uses the definition from, a dangerous weapon, that is, more than merely transient and trifling, but not necessarily permanent.
Yes.
Do you accept that definition?
I don't think it's relevant to the issue of whether I suppose that an injury could cause an impairment that was more than merely transient and trifling. But it doesn't really answer the question of what does the word impairment mean in the statute. In the case that's cited in Jean-Pierre, Commonwealth v. Lord, they're talking about a mace, whether mace can be a dangerous weapon, whether it could cause serious bodily injury. And in that case, the mace was used on a victim, and one of the effects was that her ability to breathe was diminished. She suffered from respiratory distress. So again, the issue, that could be a serious bodily injury under the statute because it does affect the function of the lungs. It doesn't last very long in most cases, but there has to be some indication, in our view, that there is an impairment.
Function of the liver is impaired.
Yes.
And if it were sprayed in somebody's eyes and temporarily caused them to render their eyesight temporarily unuseful, just because they had to close their eyes and rub them, that might qualify as...
It might, Your Honor. There's another case that is discussed in Jean-Pierre. I can't recall the title of it now, but where a child's eyes were injured temporarily. They became very sensitive to light. And this was under the maiming statute, but this was some of or the mayhem statute, some of the cases the court in Jean-Pierre was drawing on. They said that was sufficient. It was temporary, but it did disable his eyesight for a period of time. So that would be for another case. But yes, in my view, that would meet the definition of impairment.
If I could turn you to your second argument, which is that the judge permitted the jury to convict based on assaults apart from the blow to the stomach with regard to this particular crime. Was there any objection made by defense counsel to the charge and a request to limit the serious bodily injury charge only to the blow to the stomach?
There was extensive discussion in the case, and I apologize, I didn't prepare this extensively because the further appellate review was
It was limited to this issue of serious
to this issue, but I would like to answer it as best I can. That there was extensive discussion about whether it was possible that any other blows could cause a serious bodily injury, and everyone conceded, and I could probably find the site in the transcript, that the only possible blow that could cause serious bodily injury were blows to the stomach. And the judge simply told the jury that they needed to find that each assault and battery was a separate and distinct act. He did not tell them that they could only find a serious bodily injury occurred from the blow to the stomach. And I believe transcript volume 3, page 168, the judge says all parties agree and the court agrees there's only one basis upon which they can find serious bodily injury. And that's one of the two truculent blows to the stomach.
Truculent.
Truculent. Excellent word. If there's nothing else, Your Honors, I would rest on my brief. Thank you very much.
Good morning, Your Honors. May it please the Court? My name is Diane Dillon. I'm an Assistant District Attorney representing Hampden County. And
do you agree that there's a difference between injury and impairment?
No, I don't. And I think that if you read footnote 7 of Commonwealth versus Lord, it's very interesting because it traces back in the history at least to Commonwealth versus Farrell, which is 1948. And it says at times we've used the term serious bodily injury, sometimes it's grave bodily injury, sometimes it's just serious injury. But what they were trying to protect in all of the cases that were decided in the law was the health and safety of the victim. And then you go back up into the body of the decisions and they talk about what is the legislative purpose in writing a statute like this and how do we determine it? Well, sometimes we determine it just by the words because they're apparent, and sometimes we do it in relation to other statutes that are cognate that have the same purpose. And I think it's Jean-Pierre that points out that in this kind of a situation, we are dealing with an escalating series of statutes that are designed to address the seriousness of the risk of consequences to the victim. So you have assault and battery by means of a dangerous weapon, assault and battery by means of a dangerous weapon with serious bodily injury. We fought to get that.
But the risk here is only risk of death. Everything else is actual in this definition.
That's right, and it says risk of serious bodily.
No, it doesn't. It says
Excuse
serious
me.
bodily injury is defined as
Defined
bodily
as an impairment or a loss of an organ, limb, or function. And it's pretty hard to distinguish between the function and the impairment because most of our organs have pretty specific purposes in there, and this is what they do.
Yeah, but you can imagine injuries that don't impair function. I
Yes.
mean, you can imagine that you get a scratch on your knee,
Yes,
but you can still walk.
yes.
Knee is fully functional, so it can't be that just any injury or damage to a limb
No,
is an impairment.
and I'm not arguing that it is always the same thing as. And I would further suggest that in that particular instance, what you're dealing with is something that is trifling. But when we're talking about an internal organ, a liver, this is something that I want to say something else. The need for an expert is an issue that was never raised at trial. Never at any point.
Well, but you've got the burden of proof. How is a jury supposed to figure out what those medical records mean?
The medical records, some of it I'm going to suggest to you, people understand. What is a laceration? A laceration is a cut.
But what's a level
Laceration
two
can be just a
laceration?
slight scratch can be a laceration.
Of an internal organ, Your Honor?
A nick of the
A
liver?
nick? And is that trifling? Is that,
Well, I don't
would you
know
say
if
that
somebody-
with an inquiry? Would they keep her in the hospital for 4 days looking at this? Would they say it's a class 2 laceration of a liver?
Since I don't know what class 2 means, I can't tell you the answer to that.
No, you can't. But can you imagine a laceration of the liver that wasn't serious because it is internal and you have to be in a hospital subjected to these scans, which we know were performed to determine what the extent of the injury was? I think everybody nowadays knows that you don't stay in the hospital for 4 days when there's not a concern. I think everybody nowadays knows, and a jury doesn't need an expert, to know that they're not going to give you morphine. I think everybody can appreciate the fact that this kind of care, and another thing is defense counsel moved to strike every reference to her nutrition in the hospital. And now you're asking about it. So I see a tension and an unfairness, frankly, in trying to get these things out of the record, saying that you need an expert when they're trying to strike this. Nevertheless, what the jury did have is this evidence that the woman was beaten severely in the abdomen, causing severe pain when she was in the abdomen. It was so bad she couldn't stand on her own when she got to the hospital. And what was the diagnosis? It's a laceration of a liver. Well, a laceration is a cut. That's not something that's beyond the ken of your average juror. There was fluid in that cavity. Now, most of the time, there's not a fluid in the internal cavities. That's why we have the organs, and that's why the organs have coverings.
But the question is whether or not it impaired the function of the organ.
The question is the concern that it might have and did, in fact, impair the function of that organ. Otherwise, they wouldn't have kept her to see if it did.
Well, why does it have to impair the function of the particular organ that was injured? If someone gets injured in a certain way to an internal organ that prevents them from walking, does that qualify as a bodily injury under the statute?
I think that qualifies as bodily injury because it qualifies as functionality of the body has been impaired. And there are cases that say that. For instance, the cases with the mace being sprayed at someone. And although Lord probably has the most interesting discussion of the history of these statutes and how they're supposed to relate to one another, in Lord, they really just determined that mace per se, as opposed to the other things, was a dangerous weapon. But they were talking about what effect this had on the body. And it wasn't just that she couldn't breathe.
So what
It
was
was
the
also the
evidence?
tearing.
What was the evidence of bodily function, of impaired bodily function as a result of this onslaught?
In this particular one, she couldn't walk. She had to go to the hospital. She had a broken molar.
You're not saying that was related to the liver, are you?
No, his molar is not related to the liver, no, Your Honor.
Do you agree that the injury that we are focused on here is to the liver?
Yes, and the Commonwealth agreed with that initially in the motion for the required finding at pages 66 and 67. We said we were only related to the liver. If we were concerned about the risk of death, we would have had to have an expert. That's right on the record. I don't know why he keeps referring to the risk of death. That wasn't the Commonwealth's theory. The statute is in 3 parts, and one of them has to do with permanent disfigurement. That's not what we were dealing with. The other one has to do with the risk of death. That's not what we were dealing with. And that's on the record. What we're dealing with is the loss or impairment of this organ, her liver.
Okay, now, you earlier said that you're relying upon the impaired function of an organ, but I thought your position had been that the laceration of an organ, of an internal organ, is sufficient regardless of whether there's any showing of loss of functionality or impairment of functionality.
This, too, is an issue that wasn't raised at trial. We were talking about the fact that the laceration of a liver is a serious bodily injury.
Okay, but the question I have for you is, in terms of our definition of serious bodily injury, is it your position that the definition requires some impairment of an organ, impairment of the functionality of an organ, or is it sufficient simply for there to be an injury
I think
to
it's
an organ?
sufficient for there to have been an injury, and I rely on the cases that I cited, and that is what's cited in footnote 7. That is Commonwealth versus Farrell, Commonwealth versus Appleby, Commonwealth versus Tarrant. You go to Tavares, which is an appeals court case. That's the case where they were talking about he had slits in his eyeballs, in the cornea, and he also had the fingernails were damaged by some sharp instrument being placed underneath it. And that was sufficient under mayhem, which is the most
Yeah, but wouldn't the
aggravated
slits in
form.
the eyes be permanent impairment? I mean, permanent disfigurement?
I would have thought so. I really would have. But the case was dealing more with the fingernails, and that was, they did eventually heal. So citing Hogan, they said the fact that it heals isn't determinative. You can have a serious bodily injury despite the fact that it heals, even under the mayhem statute, which is the most aggravated form of all of the statute that the courts have been dealing with. What is the aim of these statutes? To protect people from serious bodily harm. Is it necessary? Now, the other thing that's interesting on this is when you look at the history of this particular statute, Senate Bill 167, when it was first filed, required that it be a protracted loss. And that language was eliminated before it was enacted. And that has been construed as being a legislative election, that the protracted element doesn't have to be there as far as the duration or the degree of harm or impairment in order to satisfy this element. And then again, I'm quoting from Commonwealth versus Jean-Pierre, and that's in footnote 7. So the degree of harm and how long it has to last doesn't fit with the legislative purpose as it's been interpreted by the courts of this Commonwealth.
Well, okay about how long it has to last, but the degree of harm, it's got to be harm that impairs a function. No?
I don't think so. Does it impair the health or safety of the victim? That is what our court said. Does it impair? That's the consequence that this is concerned with. Do you actually have to have your liver impaired so that you have to stay there and that it does require surgery? Would that be what this court wants to say about serious bodily injury? What if you're just lucky? What if they just missed? Does that make the defendant or his acts any less serious.
If he just missed, you think you could get the...
What if he missed the liver and got the spleen? You don't need your spleen, you need your liver. What if he got a kidney? You got two. But the liver? I don't think this needs expert testimony. People know that you only get one liver, and if it's damaged, you've got a problem. Does it matter if it's a class 2 or a class 4? I mean, how do we know, and this is maybe your point, that a class 2 is something to trivialize? Maybe it's the second to the worst.
Well, we
But-
don't know because you didn't...
Well, is it the point? Or does it matter that there's a laceration in an internal organ?
What if a doctor had come and testified that this injury, we see it from time to time, it's sort of like a bruising. It doesn't impair the function of the liver at all.
But we know that a bruise and a laceration are two different things. And we also know that had the issue been raised at trial, that might have happened. But this issue was not raised at trial.
Let's play it out a little bit with regard to what probably would be the most important consequence of our decision, which is with regard to a concussion. Person struck in the head,
You're struck in the head.
and let's assume there is medical records with regard to that there was a concussion. How does it play out in terms of your analysis?
It plays out, I think, in favor of what I've been trying to say. If you have a concussion, there is a consequence to the brain. There is an injury to the brain, but it doesn't necessarily mean that the brain has been impaired or that you've lost a brain function. It does, however, require, as this did, monitoring to make sure that it doesn't result in some sort of brain injury that is more severe, irreversible, or results in a permanent consequence.
It also results in restrictions on physical activity.
It does, as does 4 days of hospitalization. And to say that there were no tests
Is that
for...
treatment or prevention? Is that just to see if there's an injury because they don't want to probe something and cause a worse injury?
Yeah.
Or is it just to see if did something really happen? We'll
Well-
just keep you to see.
Well, you don't want to probe and cause more harm, that's true. On the other hand, bed rest is almost as good as chicken soup for some things. I mean, it does restrict your activities. You can't do a lot of things. It restricts your diet. It restricts almost everything. So I think it's a big picture, and I think the big picture is spelled out in those footnotes. What are we trying to do with those statutes that deal with aggravated injuries?
Right. Well, the larger picture, I gather, is that if it's not a serious bodily injury and there's no dangerous weapon, it's a misdemeanor.
Well, that's what we were fighting for when we got these statutes enacted, because too often you had a victim who was vulnerable by virtue of age, young, old, or some other disability, and it wasn't right to have a misdemeanor when they did, in fact, suffer serious bodily injury, grave injury, all of the other words that we've called it down through the years, and that this court has referred to it as. It's an aggravated assault, and it's aggravated by the degree of injury. And for us to sit down and decide that we could be a medical thesaurus and spell out all of these things in every statute is somewhat unrealistic.
But to clarify, your position is that we should add the word internal with regard to organ if it's going to be purely, you're not referring to the skin, of course, as an organ.
No, I'm not, and I think it's the only external organ. It's the biggest one anyway. But I think that, I'm sorry, I've ran on.
You can finish your thought.
Thank you very much, Your Honor. I think that we have to give this to the jury, as it always is, as a matter of fact for them to determine. Give them some guidance and some guidelines. And the jury in this case got that. We have been living with the law for years and years. It can't be trifling. It can't be transient. And I respectfully ask you to look at the footnotes, 7 in both cases. They're very illuminating.
Thank you, Counsel.
Thank you.